And there's two sets of papers that one had to go through. The first has to do with the fact that the former president, before even getting to that Section 106 plea to have lead prosecutor Billy Downer recuse himself, his legal team will actually kick off today's proceedings by arguing that having this plea being heard via a virtual platform, or rather because they've decided to move this trial via a virtual platform, this will actually contravene Section 35 of the Constitution, which enshrines that everyone has a right to a fair trial. They're saying that they would like to give oral evidence, Ayanda, in this Section 106 plea. And so if you're going to have it via a virtual platform, they won't be able to do it in that fashion. But they're also seeking a postponement for about a week, Ayanda, due to the unrest that's taken place in KZN. Quite ironic, because it seems as though most of this unrest was started by the incarceration of former President Jacob Zuma in that contempt of court, in those contempt of court proceedings. But also another irony, Ayanda, is that they're arguing, excuse me, that the COVID-19 pandemic, they want to assess the situation. Now, this is also quite interesting, given the fact that currently the former president is still under his 14-day isolation period at the Escort Correctional Facility, where he is being monitored for COVID-19. And also, they're arguing to have him come appear in court despite, the COVID-19 pandemic. And yes, on previous occasions, Ayanda, the former president's lawyers, albeit it was his previous legal team, led by Advocate Moses Kakane, argued that he's an old man and he shouldn't be subjected, to the possible risk of contracting COVID-19 by coming to these, by coming to this court that I'm standing outside right now. So we're expecting those proceedings. The state is expected to argue that this is another delaying tactic by the former president, and that they were well aware of the lockdown level 4 regulations, and so there's no need for them to now come and argue that they want to have this via virtual platform, given the fact that they've also been privy to information that there have been threats not only to this court but to the judges and the legal teams. Ayanda.
Yeah, and Ziyanda, Judge Kuhn, as a symbol of the High Court itself, has given reasons for why they believe this should be a virtual sitting. What did they say?
Absolutely. So Judge Kuhn outlined these very reasons. One of them is what I've just touched on now, that there were threats, to this court and the judges and the legal teams, but also because of what we've seen taking place outside this court every time former President Jacob Zuma comes to appear for this arms deal case, that there have been several contraventions of the lockdown regulations, and so it would be best to have this particular hearing via a virtual platform. Those are just some of the reasons that the judge has outlined, and also that it's possible to appear via a video link from the Escort Correctional Facility, which is what Justice and Correctional Services Minister Ronald Lamula had said a few days after the former president was incarcerated. So, on the basis of that, we're expected to hear firstly what Judge Kuhn is likely to say in this regard, but Zuma's legal team quite clear that they want to have the Section 106 plea heard via oral evidence and not just deposing of the affidavits.
And all of this, Ziyanda, just means that we really are still a while away from the trial itself actually getting underway.
Certainly. I mean, after that particular matter is heard, and we don't know how long it will take, the former president's papers are around 25 pages. That of Billy Downer in relation to whether or not this should be heard virtually is about 60 pages. And I don't know if all the documents in their entirety will be read out. And then we still need to get to that Section 106 1A plea, according to the Criminal Procedures Act, to have Billy Downer recuse himself. You'll recall we'd heard from Advocate Dalimpo, who's the lead counsel for the former president, touching on some of the arguments, but in the main, Ayanda, they'll be arguing that there's been prosecutorial interference, that Billy Downer does not have a title to prosecute by virtue of the fact that he joined an application by the Democratic Alliance to overturn a decision to actually, stay the prosecution against the former president. They're also citing political interference, much like they did when they actually filed that permanent stay of prosecution application last year, Ayanda. And this has been the criticism made against the former president's lawyers and the arguments that they've outlined, that it seems as though it's a regurgitation of what we heard during that permanent stay of prosecution application, which we know was denied. And one of the key things that the courts had found was that the Supreme Court of Appeal has found in a judgment that even if there has been political interference in a matter, for as long as there's evidence that is enough to prosecute, the matter can proceed. But also, secondly, Ayanda, when it comes to these issues of, when in the permanent stay of prosecution application, the court found that he was not prejudiced. The former president was not prejudiced by those spy tapes, by that Brownsville report, by virtue of the fact that despite all of this political interference, he was still able to ascend to the highest office in the land. So the arguments to have Billy Downer recuse himself will be quite interesting, and that team will be led on behalf of the NPA by Advocate Vim Trengove.
Well, thanks very much indeed. Plenty to look forward to. As soon as those proceedings get underway, no doubt we'll be touching base with you in the lead up to that moment.